Chief Justice of Delhi High Court, Chetan Sharma, my friend, ASG, Delhi High Court, Mohit Mathur, my friend, Delhi, President Delhi Bar Association, Vikram Yadav, Neeraj Ji, Gupta Ji, distinguished members of the bar, friends, ladies and gentlemen. Mine is not a keynote address. It's not even a keynote. It's not even a key address. But because I had to catch a flight, I've been given precedence. So please don't think that by any chance that I'm the premier speaker. The main speakers are Honorable Minister and the Honorable Acting Chief Justice, and the rest of us are all the supporting cast, including me. Now, this is a subject which I've written articles, been asked to speak on a number of symposiums. It's a subject on which I've had an early association. During COVID in 2020, the Home Ministry constituted a panel, a committee for this reform of the three criminal statutes. And we had a chairman, some members, there was an academic, Professor Bajpai, who chaired it. Many students participated, and we were given a mandate to finish it within a particular period of time. Thanks to COVID, I think we finished it even prior to the time schedule that was given to us, and we submitted our recommendations to the Home Ministry for the consideration of the various heads of ED, CBI, so on and so forth, because obviously being lawyers, and most of us defense lawyers, and students who are liberal in attitude, it was expected that we'd be very reformist and liberal in the provisions, and so they wanted it to be diluted by the various agency chiefs. And to some extent, that's what's happened. It's a happy mixture of liberal lawyers looking at it from the perspective of from human rights, etc., and the security of the state and the interests of the state by the various agencies. Now, first of all, one thing was unanimous by everybody who participated, including stakeholders who came for these committee meetings. Subsequently, they came before the Home Ministry and its officials as well. And one thing was unanimous, that these laws were indeed colonial. They were of great antiquity. The Indian Penal Code was of 1860. The Criminal Procedure Code was of 1898 and then amended in 1973. And of course, the Indian Evidence Act was of 1870. So these required, in any event, they were outdated. And it is really surprising. If you look at some of the provisions that remain in the statute book, it is really surprising that these colonial provisions were allowed to stand. They should have been looked at long time back, except for the Criminal Procedure Code, which really did not bring in sweeping reforms, the 1973 Criminal Procedure Code. But there have now been, I might say, right, and this might be a little bit of lack of humility on my part since we started it all in the Criminal Law Reform Committee, that there have been fairly sweeping changes made, and changes which were in the right direction and changes which were needed to break with our colonial past. Now, since there's a paucity of time, very briefly, I'll give an overview of the three statutes. What was colonial and what is emerging India. First, there is the Bharatiya Nyaya Sanhita, which replaces the Indian Penal Code. Now, this act was amended a few times, the old Indian Penal Code, since independence. But the amendments were mostly formal. For instance, offences by public servants were removed from a particular chapter. Sections 161 and 165 of the old Indian Penal Code. And all these sections were put under the Prevention of Corruption Act. So they were removed, these corruption offences were removed from the Penal Code, and a new act dealing specially with corruption by public servants was enacted. A second type of change which was brought about was basically a knee-jerk reaction to events that took place in this country. So when we had the horrendous Nirbhaya episode in 2013, I believe it was, we had the provisions under the Nirbhaya Act, and a lot of the sections of the IPC were amended. The sections pertaining to rape, the sections, but and new sections were added. Voyeurism, we're all familiar with those that came in post Nirbhaya. So it was a knee-jerk reaction. How effective it has been is for present and future generations to decide whether the new teeth given to the law has effectively provided the deterrent. But my own personal view is that replacing laws is one thing, but attitudinal change, patriarchal attitudes in particular, need to change before offenses of sexual offenses and the like can really be eradicated from the country. But that's another subject. Now, what was it about the existing Indian Penal Code which needed replacement? Sedition. Sedition, so there's a strong thrust in the Indian Penal Code or the new Bharatiya Nyaya Sanhita. There's a strong thrust towards security of the state. That is the first feature. Now, sedition, for instance, was a purely colonial law, as defined. 124A was a purely colonial law, and it was meant to protect the colonial regime. The statute 124A basically punished disaffection with the government by law established. Now, this was basically an act meant to protect colonial rulers from its colonial subject. So when modern India got independence, 124A was often invoked when you had seditious writing. And people used to say, but this is a colonial law because it's meant to protect the government. It doesn't protect India, it protects the government. So the sedition law was basically, the wording of the sedition law was basically meant to protect, as I said, the colonial masters of that time from any sedition by their colonial subjects. The new sedition law has made a very significant change. The Sanhita now seeks to remove this anomaly with new section 152. It eschews the word sedition. Sedition doesn't exist in the Sanhita anymore. But it talks about, the offense talks about any act endangering the sovereignty, unity, and integrity of India. The section imposes a life sentence of imprisonment or imprisonment up to 7 years and a fine for anyone who by written or spoken words excites or attempts to excite. Now, there are very clear actions which are punishable under the section. It's not vague disaffection. The word disaffection is no longer used. The word is excites or attempts to excite, secession, which means breaking away, or endangers the sovereignty, or subversive activities, or encourages feelings of separatist activities, or endangers the sovereignty or unity of India. So, the words brings into hatred or contempt or excites disaffection towards the government established by law in India, which was under section 124A, has been dispensed with. And now we are not concerned with the government of the day, we are concerned with the security of the Indian state. And that is a very significant change. It is a marked departure from colonial legislation